So now getting into today's session, I'm very pleased to be launching this. It's the first in a new series that we're starting here at PHAP based on the interest and suggestions of PHAP members who are focused particularly on international humanitarian law and related policy issues. This new series is of expert IHL briefings, and for this first PHAP online expert IHL briefing, we'll be welcoming two of the authors of a recent report coming out of the Harvard Law School Program on International Law and Armed Conflict, that's HLS PILAC, to present their research on IHL and medical care concerning terrorists in armed conflict, and looking particularly at the vitally important question of how state responses to terrorism potentially threaten to erode the foundational ethic of IHL entailed in impartial wartime medical care for all wounded and sick fighters, no matter which side they fight on in the conflict. So we're very pleased to welcome our two experts, Modirzadeh, who is the founding director of the Harvard Law School Program on International Law and Armed Conflict, as well as Dustin Lewis, senior researcher, also with PILAC. And we're going to begin by turning first to Naz to introduce the research, and then we'll go to Dustin to walk us through a number of the key points that have come out of their report. So first, over to you, Naz.
Herod, it is apologies, I think I started a bit too quickly. Thank you so much, Herod and the whole PHAP team for having us. It's really a pleasure, and I must say we have a tremendous group of individuals joining us today for this conversation. I recognize many names of friends and colleagues, and many people that I really admire. So it's really an honor to be with you all today. And my hope is that what we'll be able to do is to take about 25 minutes to give an overview of our recent research, give a sense of how we came into working on this topic, what our goals were in the research, and my colleague Dustin Lewis, our senior researcher, is going to really step into some of the more complex legal questions, and then hopefully to engage in a discussion. We are certainly not the only organization that is working on issues of medical care in armed conflict. Many colleagues at the ICRC and at MSF, of course, have been thinking through these dilemmas for quite some time, and our hope in doing this work is that some sort of deep dive research on international humanitarian law and counterterrorism would be constructive in supporting the efforts of operational and other organizations. So without delay, I'm going to move on to give a few introductory comments and some framing sort of for how we ended up working on this question. As many of you know, we run a project called the Counterterrorism and Humanitarian Engagement Project. And we look in that project at sort of the intersection between counterterrorism laws and measures and principled humanitarian action, both at a domestic level but also at the Global Security Council level. And about 2 years ago, as we were doing that work, and of course as the crisis and the conflict in Syria was worsening, and sometimes I feel like in those days we thought it was at its worst. Tragically, I think we were mistaken in that sense. We heard from many of our CHE working group members that they were increasingly finding that they were facing particular dilemmas in the arena of medical care in Syria, that they were increasingly realizing that doctors and other medical professionals felt a real tension between, on the one hand, their ethical and normative commitments as doctors, and for some of them, their ethical and normative commitments as humanitarian actors to provide medical care based only on medical need, and a sense that the Syrian government, and indeed in some cases donor governments, very clearly were framing medical care for terrorists as a crime. Even as something where you could be targeted in the case of the Syrian government. And so our sense was that this was an area where counterterrorism laws and measures might be coming into direct tension with one of the foundational norms of international humanitarian law. Those of you looking at the screen will see that we have a quote here from the commentary on the first Geneva Convention, and I think this is a set of sentences that for us I think really wove through the entire project and the research effort. And I'll just quote here very briefly. It says, "It follows that medical treatment, even where given to enemies, is always legitimate and does not constitute a hostile act. Medical personnel are placed above the conflict." And we found this notion both throughout the commentary and the treaty text itself, but also in much of the drafting discussions that we looked at very closely and that my colleague Dustin will talk about in greater detail. A real sense that one of the key innovations of international humanitarian law, one of the aspects that IHL not only introduced but then secured consensus around, was the idea that IHL demanded that you provide medical care for friend and foe alike, for enemy and your own soldier alike, and that those providing that care be protected and not be seen as supporting the enemy. And so it was that notion and that sense of attention that led us into this project, and a real sense that this was not just a theoretical or an abstract legal tension, but rather one that was actually affecting humanitarian actors and medical professionals on the ground seeking to provide much-needed medical care in Syria and, of course, as we realized, in many other contexts as well. So two root questions informed the research and took us into some of the more technical IHL and counterterrorism issues. The first was, in conflicts involving terrorism, should and can medical care remain above the conflict? And what we were looking at here was this question that so many of us have been grappling with over the last 14 or 15 years. Does terrorism suggest some kind of new conflict that changes the rules, that changes some of our fundamental assumptions about how law regulates warfare? And second, is there something different about armed conflicts involving terrorism, and particularly armed conflicts that are non-international in character involving terrorism, and the kind of traditional model on which most of the IHL norms were created? And if so, what does that mean as we start to talk about things like the so-called global war on terror or extraterritorial non-international armed conflict, situations that seem to themselves stretch the boundaries of our definitions and classifications of armed conflict? What happens to medical care and to protections for medical care in those situations? So that was really our background thinking, the questions that were animating us, and our ethic, if you will, in going into this was we wanted the research to guide us. We really wanted to come at these questions genuinely and with a spirit of inquiry. And it's with that I'll hand it over to my colleague, Dustin Lewis, who led our research efforts along with myself and our co-author, Professor Gabriela Bloom. I'll hand it over now to Dustin.
Excellent. Thanks very much, Naz, and thanks so much to Anherod, Marcus, and the whole PHAP team for inviting us to take part in this very innovative idea for these expert online IHL briefings. It's a deep pleasure to be involved and to also see so many friendly names in the attendees list and so many people whom I have such a deep, deep respect for. So in the next 15 to 20 minutes, I plan to do a few things. First, I'm going to go over some of the foundational concepts that underpinned our research. I'm going to just very briefly mention some of the key parts of IHL and the key parts of the legal considerations regarding state responses to terrorism. Then I'm going to move into a section where I'll highlight at a very high level, what for the last 150 years IHL has had to say about impartial wartime medical care, and what the progressive development of that has looked like, sort of in terms of a trend line. Next, I will look at the key protections underpinning impartial wartime medical care for terrorists in particular, and then I'll look at state responses to terrorism, and then look at fragmentation within the IHL landscape. I'll be trying to go through a lot of the research. Unfortunately, it's a quite long report. The executive summary is relatively short, but most of what I'm going to be discussing will track pretty closely to a lot of our main research insights that are in the report. So in the next 15 minutes, I'm going to try both to have a broad level view, a sort of 30,000-foot view, and where it might be most relevant, also try to come in with a very, very, very close reading of some of the relevant legal provisions. So with that, I'll move quickly now, just given that this is an expert briefing, we won't belabor too many of these main points. But the first one, of course, and the very important one, is that there's no generally agreed upon definition of terrorist and terrorism in international law. So when we talk about state responses to terrorism here, we do so with resort to the definition as relevant, whether found in international treaty, customary international law, a relevant Security Council resolution, or at the domestic level. So again, we know that there is no terrorist designation that is universally applicable in international law, and so we're resorting here to whatever the states consider, because we take, of course, very seriously what states consider to be the definition of terrorism. As almost everyone here certainly knows, there's two types of armed conflicts under IHL, at least as recognized under the legal regime: international armed conflicts and non-international armed conflicts. We'll go into some of the details of how impartial wartime medical care might look a little bit different in certain respects for states and organized armed groups engaged in those different types of conflicts. And then a very, very, very important element here. Status and or function is key in IHL to discerning the status of the legal protection or the scope of the legal protection. The status between combatant fighter, there's the civilian status, civilian directly participating in hostilities, and then there's this medical personnel status. So each one of these, depending on the applicable IHL provision, whether a treaty provision or customary rule, will have a slightly different content to it. But again, it's just as a foundational element, we want to note here that it's important to be able to discern exactly what IHL considers the person's status to be based on their status, their function, their role, etc., within the armed conflict, in order to discern the exact scope of protections pertaining to that individual medical caregiver. IHL, of course, imposes obligations primarily on the parties to an armed conflict. Civilians, though, also have important protections under the legal regime, not least to be able to initiate a medical care response to the wounded enemies in the field, and we'll go through that as well. But I think it's important just to, again, stress, IHL primarily imposes obligations on the parties here, and this will get us, I think, to the rationale of the legal regime, especially with respect to the control necessary for medical personnel units and transports to gain so-called special protections under the law. More on that later. Lastly, we are going to be focusing primarily on IHL. Of course, international human rights law, international criminal law provide additional normative protections here, and some, depending on the applicability of the rule or instrument, can also provide applicable additional legal protection. But for the most part, IHL is extremely specific when it comes to wartime medical care. This was the raison d'etre of IHL beginning in 1864, and it has many, many more specific and many more provisions than IHRL or ICL. But that said, of course, it's necessary to get a full grasp of the law to be able to look at all of the different overlapping normative frameworks in aggregate. So where relevant, we'll try to flag those as well, but just noting here, we're going to be focusing mostly on IHL. All right, so as I'd mentioned, since 1864, states have put medical care, and in particular, impartial wartime medical care. Impartial here meaning that it's provided based on need, not necessarily on neutrality, so it's not as if it's not a question of it's providing, impartial here means that it's provided based on the individual, irrespective of his or her affiliation, on grounds of medical need without any other form of adverse discrimination. This is a really important part, and that's why we put impartial in front of so many When we say medical care, we put impartial in front of it because we think this is a very important legal ingredient to the formula because it really gets to the heart of the matter. Since 1864, states have said that medical care, including and perhaps especially to the enemy, is above the conflict. If they're wounded, you need to treat them. The legal regime has at each stage of the main IHL drafting, has progressively developed protections for the wounded and sick. Initially, it was reserved primarily for wounded and sick combatants. Then, decades later, you also have legal protection at the international level for wounded and sick prisoners of war. And then subsequently, you also have wounded and sick, you have protections for civilian wounded and sick. So initially, again, it's for combatants, then prisoners of war, then ultimately for civilians. Here we underscored that it's corollary protections for medical caregivers and the means they need to do so. So what do we mean by corollary? Corollary means primarily that the underlying protection for medical care is for the person who is wounded and sick. If you don't have a wounded and sick person, you don't have a need to provide protections for medical caregivers and their means. It's not the primary protections for medical caregivers, it's because of their function in providing medical care. It seems like a basic point, but I think it's a really important one underlying much of the rationale of the legal regime. Okay, and then over time, of course, you have this increasingly thick set of IHL treaties. All of them, by the way, interesting, written with their authentic version only in French up until 1949. So for our Francophone colleagues, it very much helps to be able to read legal text in French because the authentic versions are only in French up and through the first 50 plus years or so of these treaties. Then customary IHL, of course, also develops alongside of it. And so you have today a combination of treaty-based provisions and customary IHL provisions. More on the exact scope of those later. And at some point, there's going to probably be disagreement even among the different people here today about the exact customary, the scope of the customary IHL rules concerning medical care. I'll just try to make it more interesting for later, I'll say we don't actually agree necessarily with all of the evidence put forward, for instance, in the customary IHL study by the ICRC. While that's an incredibly important study and has a lot of evidence to it, we're not necessarily convinced that there's been sufficient evidence of states' buy-in, at least for all of the medical care provisions that are listed in the ICRC customary study. So again, key normative points, 1864, you have the establishment of impartial care for the enemy and protections also, and very importantly here, for unassigned civilians. Unassigned here meaning that to get special protections, we'll detail a little bit more later, you have to be assigned and recognized by one of the warring parties. But from the outset, IHL has also provided other protections for civilians, medical caregivers, even if they're unassigned by one of the warring parties. This is at the root of the legal regime. 1906, you have recognition of voluntary aid societies for the first time. But again, interestingly, as you'll see in the Geneva Convention 1 and other instruments, these voluntary aid societies gain the medical personnel status by being authorized and recognized by a party to the conflict, by being subject to military law and regulation. 1929, extension to prisoners of war. 1949, you have the partial extension to civilian wounded and sick, and then you have what I consider one of the most important innovations, which is in Geneva Convention 1, Article 18, Paragraph 3, you have non-punishment for nursing the wounded combatants in armed conflicts, in international armed conflicts. This is vitally important. 1977, you have the full extension to civilians, removing any ambiguity in the underlying instruments previously, and then you also have the extension of the non-punishment of medical activities for anybody engaged in medical activities compatible with medical ethics under AP1 and AP2. But whether or not those reflect customary law, I think, is more of an open question and one that we'll address a little bit later. All right, so what do we have with state responses to terrorism? So in this section, I'm going to try somewhat briefly to just say what exactly you have at the international level, focusing on the Security Council, and then focusing at the domestic level of how 3 states, Colombia, Peru, and the United States, have instituted legal proceedings concerning caregivers in relation to terrorists and war. So, what's the summary? Since at least the 1930s, terrorism has been a matter of international concern. this is 7 decades after the first IHL treaty on medical care. But you don't have, until the 1960s, an actual international terrorism treaty going into effect. And it's really only since the late 1990s that you have a really big increase in the focus on and the number of counterterrorism measures at the international level, and especially with the rise of the Security Council. The main rationale that I want to highlight here is that some state responses to terrorism recast medical assistance as impermissible support to terrorists. Okay, so this is a normative approach that is different than the IHL approach. All of a sudden, the idea that medical assistance is no longer above what they would consider conflict, and instead it shifts to the idea that medical assistance, as with so many other resources or services or other forms of support, are recast as being impermissible support to terrorists. The UN Security Council, many people who are taking part in this will know this very well, that Resolution 1267, initially against the Taliban, then Al-Qaeda, with imposing a sanctions regime alongside of what's known as the 1368 or 1373 line of resolutions. Those impose obligations on states to give effect in their domestic regimes to certain counterterrorism obligations to ensure that their territories, their nationals, and others aren't used for, aren't engaged in supporting terrorism. Those, now there's well over 2, possibly 3 dozen combined sets of resolutions since 1999 that have developed in these interconnected sets of binding resolutions, which all UN member states must give effect to pursuant to the UN Charter. And yet, so two big points of the UN Security Council. One is there's a lack of explicit IHL exemptions. Only for 2 of the Security Council imposed counterterrorism obligations, the first one being incitement to terrorist acts, and the other one being suppressing certain forms of support to foreign terrorist fighters. For all other UN Security Council imposed Chapter 7 mandated counterterrorism obligations on states, there is not a direct provision within the operative paragraph requiring the state, when giving effect to that obligation, to allow to provide an exemption under IHL, even if what the activity they're talking about could be read from a legal perspective as to encompass things that would otherwise be protected in IHL, such as impartial medical care. Second big point, the Al-Qaeda Sanctions Committee, under the 1267 regime, they designate individuals and organizations that are associated with Al-Qaeda. In doing so, they subject those individuals and organizations are subject to an arms embargo and other penalties. There's a travel ban, and there's one other component which is escaping me right now. But for 2 of the individuals and 2 of the organizations listed by the Sanctions Committee, in listing those individuals and organizations, the Sanctions Committee included medical care or referenced some element of medical care among many other much more traditional forms of terrorist activity, things like actually intentionally bombing civilians. And so we're left with this question of whether or not the Security Council, through its subordinate body, the Al-Qaeda Sanctions Committee, actually thinks some forms of medical assistance alongside of more traditional forms of terrorism constitute impermissible support to terrorism. Quickly, here's a map that we did of all of the listed locations of Security Council designated terrorist organizations. So these are all of the 1267 regimes. This is their home base as listed by the Sanctions Committee. It's either their address or their operational area of the designated entity. We didn't look at individuals too, that would have been even bigger on the map, but you can just see the global nature of the Security Council regime. At the domestic level, states are, of course, bound to give effect to their binding Security Council counterterrorism obligations. So they have to take the steps necessary to impose a travel ban, asset freeze, etc., on the Al-Qaeda and associated terrorist lists. But then, and of course also to implement any of their counterterrorism treaties. But those are floors. States then can also build on top of that and do more to try to undertake effective responses to terrorism, or what they perceive as the threat from different forms of domestic or transnational or international terrorism. For some states, and again, very important to note, not all states, but for some states, they are increasingly they're adopting increasingly expansive notions of what constitutes impermissible support to terrorism. And for some countries, this includes medical care given to people designated as terrorists in armed conflict. An important note here too is that a lot of these laws are drafted in ways that gives them extraterritorial effect. So even if, and many times the extraterritorial effect is not based on a nationality or passive personality principle, but rather on the universal jurisdiction approach, saying that terrorism anywhere is a threat to everybody all the time. So under this view, for instance, the U.S. Material Support Law, it encompasses the activities of, for example, a French national physician acting in relation to al-Shabaab in Somalia without any other connection to the United States other than that the U.S. considers al-Shabaab to be engaging in terrorism. As I'd mentioned before, in the report we look at the practice of three different states, Peru, Colombia, and the United States, when it comes to instituting legal proceedings at the domestic level against medical caregivers. These cases are incredibly dense, incredibly important, and I'm not going to do justice to them here. I recommend reading the actual cases. I'm happy to provide the links to them, but the thumbnail versions of each is as follows. In Peru, during the 2-decade-long non-international armed conflict between the government and organized armed groups, including the Shining Path, a number of doctors were brought up on counterterrorism criminal law violations, including one doctor named Dr. De La Cruz Flores. Dr. De La Cruz Flores is unique in some respects in that she had her case ultimately brought in front of the Inter-American Court of Human Rights. What the Inter-American Court of Human Rights finds is that Peru had violated the principle of legality. This is the legal principle more or less saying you have to make it known with sufficient clarity and specificity about what exactly is unlawful so that you put people on notice about what's considered prescribed and what isn't. Dr. De La Cruz Flores in 1990 had been accused of providing cover for someone who in her office were putting up stickers for supposedly in support of the organized armed group, the Shining Path, but then on a subsequent set of charges, so it's a slightly separate one, although the jurisprudence gets really confusing, she was also charged with on collaboration in support of terrorism by providing medical care to members of the Shining Path. Ultimately, the Inter-American Court of Human Rights, as a human rights court, does not make legal determinations concerning IHL. They do make legal determinations concerning IHRL, International Human Rights Law, but they do reference IHL in the decision in important ways. In Colombia, the question becomes one intermixed not only with the domestic crime of terrorism, but also the crime of rebellion, and these two get interlinked very closely. When Colombia became party to Additional Protocol 2 in 1944, all of a sudden a provision in the Colombian anti-rebellion law, which expressly included medical support to rebelling factions, was legally invalidated. And yet after that, there's been a number of cases regarding what exactly is protected. Is it just trauma protection, legal medical care provided to victims of trauma to do immediate trauma, or is it for long-term medical care management? And there's a recent case saying effectively that if you are engaging in the long-term care management of the FARC, that actually is not encompassed in what we consider to be that impartial wartime medical care protected pursuant to IHL. Now lastly, in the United States, there's two important cases that we highlight. The first one is of Dr. Rafiq Sabir, the so-called, quote, on-call, end quote, al-Qaeda a doctor for al-Qaeda, who was ultimately accused, convicted, and imprisoned for 12 years for attempting to provide material support in the form of medical support to wounded jihadists the next time Dr. Sabir would go to Saudi Arabia. And then we also have the case of Mohammed Abdul Warsami. Warsami's case is very peculiar. Ultimately, it did not hinge on medical care concerning terrorists in armed conflict as such, but one of the charges and one of the legal rationales that now is binding precedent in one U.S. court district establishes that giving training to nurses in Afghanistan so that those nurses can be able to understand English medicine labels is unlawful support to terrorists. And the rationale being that if you provide nurses with that English language medicine training, they will be able to provide medical care to wounded al-Qaeda members, wounded jihadists, and that will speed up the recovery so that they'll get them back into the battlefield. Now, the key sets of IHL protections, there's two big ones. The first one is the entitlement to and protection of medical care for wounded and sick or to combat. Or to combat here meaning that it's not just that if you have the condition of being wounded and sick, you fall under the protections. If you're a wounded and sick fighter or combatant, depending on the applicable law, you also have to remove yourself from hostilities. If you continue to fight, to shoot your gun, you're not yet or to combat. So it's important to recognize that the or to combat there has an important legal characteristic. And the second one, again, are these corollary protections for medical caregivers, units, and transports and supplies. But first, who and what is exactly protected? Under IHL, who constitutes the wounded and sick? There's no general definition. One's given in additional protocol 1, but that's explicitly for use only in that protocol. But everybody understands it's more or less the condition of being wounded and sick. But now to the more tricky question of who constitutes medical personnel and what constitutes medical units and medical transports. Having gone back through the drafting history of the Geneva Conventions from 1864 onwards, up and through the Additional Protocol 3 of 2005, our take is that to obtain the medical personnel status, and this is confirmed in the ICRC customary study, those individuals and those units and transports must be exclusively assigned to provide medical support from one of the parties to the armed conflict. But what's the rationale for that? So why require that control? Why require the authorization and recognition by the parties? It has a lot to do with the question of whether or not the warring parties will trust each other enough to protect medical care and ensure that medical care wouldn't be abused, to keep medical care above the conflict. The most important manifestation of that is on the issue of the use of the emblem and not misusing or abusing the emblem. So that brings up the question of what about unassigned caregivers or unassigned hospitals and other healthcare facilities. These are more specific and difficult legal questions, but when it comes down to in general, unassigned caregivers, so those who are not medical personnel subject to the authorization and recognition by a party, are generally considered civilians. They might have an intermediary level of protection because they're providing medical care for the wounded and sick. And when it comes to hospitals, there's a treaty-based difference in international armed conflicts versus non-international armed conflicts. The international armed conflicts, there's express recognition under GC, Geneva Convention 4, Article, I believe it's 18, for civilian hospitals organized to take care of the wounded and sick. But in non-international armed conflicts, there's no explicit treaty basis for protection of unassigned hospitals. As such, so those would be civilian objects caring for the wounded and sick, at least pursuant to the treaty regime. Whether or not the customary rules strengthen that or convert them into a greater protective level is a question not resolved, of course, by the treaties themselves. So I won't go through the key protections as such. These are the subsidiary protections within the different two sets of main ones. And instead, I'll just highlight very quickly 5 areas that are under or unregulated by IHL. The first is that in non-international armed conflicts to which AP2 does not apply as a treaty, there's protections under Common Article 3 and customary IHL. Depending on what evidence you're looking for, some people will argue that there's almost the equivalent level of protection, others will argue that there isn't. For our part, we looked through all of the evidence cited by the ICRC customary IHL study, and they for a number of the provisions, especially Article Rule, I believe it was Rule 26, didn't cite the practice of any states that are not party to Additional Protocol 2. What's tricky here is that the ICC Rome statute, where it applies, actually provides this intermediary level of protection, especially for hospitals and for other places where the wounded and sick are protected. But under IHL, Common Article 3, as treaty law, is very basic, and that's one of the main reasons why Additional Protocol 2 was drafted, was to extend more explicit legal protections for impartial wartime medical care to non-international armed conflicts. The capture and retention of medical personnel is unregulated under IHL treaty law. There's no definition in AP1 and AP2 of medical ethics, thus potentially leaving states an overbroad margin of appreciation for abuse, though international human rights law and international criminal law can obviously provide very helpful normative points of reference and legal bases for these questions. IHL non-denunciation provisions, which are those that would protect doctors from having to report not only on the health information but the other information of the people under their care, are subject to domestic legislation. So again, subjecting an international legal norm to domestic legislation is very bad for the international legal norm. And then lastly, there's no IHL protections as such for international boundary travel of medical caregivers. So if you're seeking to go from your state to another state, IHL does not protect that as such, despite modern international travel being much, much, much easier. All right, so some of the fragmentation in the protective landscape, I won't go through these in detail. They're in the report. But for international and for non-international armed conflicts, we went through and said, does the Geneva Conventions, does AP1, and does the ICRC study for international armed conflicts, and does Common Article 3, AP2, and the ICRC study for non-international armed conflicts provide the same level of protection and provide what we would consider sufficient level of protection and evidence of that protection? We did this for the first set of protections, which are those concerning entitlement to medical care for the wounded and sick, and as well for the corollary protections for medical caregivers, units, supplies, and their transports. So hang with me, I'm almost done. This is the last slide. So what's the upshot of our analysis? When we look at the normative landscape today, we think it's unsatisfactory. While there are very important protections for wartime medical care, we think that states' commitment to these, the commitment to the underlying ethical foundation is not fully sufficient, at least not yet. And we were very concerned that state responses to terrorism are not sufficiently taking into consideration the 150-plus year history of the protections for impartial wartime medical care by all of a sudden recasting medical support as impermissible support to the terrorists. So for some prosecutions of physicians supporting terrorists through medical care likely constitute at least an IHL treaty obligation violation for some states. But in other conflicts, situations where there's, and states intentionally curtail impartial medical care, we don't think there necessarily is an IHL violation, and we think both those actual violations and the lack of clear ones are problematic for the underlying norm. Lastly, we are concerned that states at the international level, at the Security Council on downward, as well as at the individual state level, are not duly considering what might be lost as they revise these ideas on terrorism there's the real risk of potentially eroding one of the foundational normative pillars of international humanitarian law. So with that, I'll hand it back over to on Herod and jump into any of the questions, and very much looking forward to the discussion.
Excellent. Thanks so much, Dustin. Great work and an excellent presentation of what was a very weighty and long report. So thanks again for that. We've had a few questions come in. I would definitely encourage anyone else, now that the presentation is over, I know that you are all listening with great attention, but now if you have questions or comments on your mind, please do feel free to put those into the Ask a Question box. We have an interesting question that's come in from Jamal, and so I'll hand the mic over to either Naz or Dustin. You can sort it out between yourselves. I think to address Jamal's question, he's asking about whether impartial medical care providers are actually obliged by the provisions of IHL or states' domestic laws to hand over so-called terrorists after their full recovery to the state forces. Is it a violation of international humanitarian law for the state forces to keep impartial medical treatment facilities under armed watch, thus deterring access to these facilities? As a related question, is it permissible for the state forces to make arrests from the impartial medical facilities? So over to Naz and or Dustin.
Great. Thank you so much, Inherit, and thanks, Jamal, and forgive me for using your first name. I don't have your surname in front of me, for the great questions, and questions that we really were also hearing from practitioners as we were working on this. So I think I'll just, if I can, frame the two big questions that I think come out of your insights, and then I'll hand it over to Dustin to talk to us a little bit about the law. So I think question number one is, from the perspective of a party to an armed conflict, and particularly a state, if what you are doing as a medical care provider is simply patching people up and sending them back out to go fight, how could that be protected? Isn't that the very definition of providing support to a non-state armed group or the enemy? So I think that's number one, is it's sort of how does the law address that question? And two is a really tough question that we thought about a lot. What, if any, can a state require from medical care providers in terms of providing intelligence and information? So if you are a doctor in a clinic, and let's say, I'll just give a sort of dramatic example, but let's say you were a doctor in a medical clinic in southern Afghanistan, and Mullah Omar, all of a sudden you walk into the clinic room and you see the eye patch and you realize it's Mullah Omar. Can the state, can a party to an armed conflict require that you make a phone call, go into the other room and say, just so you know, Mullah Omar is here? And how does the law deal with the reality that medical professionals might often be in a position to hand over high-value individuals from the enemy forces? Let me hand it over to Dustin with those two.
Excellent. Thanks, Naz. And thanks very much, Jamal, for that question. So my take on it is to go to the source of the law. So what are we talking about here? What type of armed conflict are we talking about? The first question is it an international armed conflict, or is it a non-international armed conflict? Many of these counterterrorism concerns arise primarily in non-international armed conflicts, though of course not all of them. So let me focus primarily on non-international armed conflicts. So that gets us to the subsidiary question of what law actually applies to non-international armed conflicts involving designated terrorists. Here, if we take Afghanistan, Syria, Yemen, Somalia, the Philippines, Peru as examples, you'll find that different treaty provisions apply based on whether or not the underlying state has contracted into the relevant treaty. So at a minimum, of course, all states in the world have contracted into Common Article 3. That's now also considered to reflect customary IHL. But what exactly does Common Article 3 get you when it comes to protections for wartime medical care? The ICRC's answer in the 1960s was a lot, but not enough. And that's why they developed additional protocol. Well, that's why they very strongly supported the development of additional protocol 2. But under Common Article 3, any impartial humanitarian organization can offer their traditional services to any of the warring parties. And under Common Article 3, all the wounded and sick must be collected and cared for. But again, these are obligations primarily on the parties to the conflict, not necessarily on the civilian population as such. So again, if we're focusing primarily on non-international armed conflicts, you're going to get a lot more protections under Additional Protocol 2. So let's move to that. What do you get under Additional Protocol 2, assuming that that applies? And again, it's really important to recognize that Additional Protocol 2 applies to far fewer non-international armed conflicts because it has a much higher threshold of application under Article 1.1. That requires that the treaty can apply only with respect to situations of non-international armed conflict between one of the states and on its territory, so it has to be on its territory, and an organized armed group or dissident armed forces controlling territory with the capacity to give effect to the treaty provisions, etc. Nonetheless, if Additional Protocol 2 does apply, you get many more specific treaty protections here. Some of the key ones are as follows. You would be protected as a medical caregiver under Article 10.1 from any form of punishment being imposed on you so long as you, in engaging in medical care activities, and this applies irrespective of whether or not you're a medical personnel assigned by one of the parties, but if you are engaged in medical activities that comport with medical ethics, you cannot be punished by the state for whom that is applicable. So what does medical ethics mean? Medical ethics is undefined in the law. There's been really important work done by academics and by non-governmental bodies and others to try to give shape to what medical ethics means in this realm. There's also international human rights law, and especially with respect to the right to health, and international criminal law prosecutions that have given some form to what medical ethics counts here, but it's not completely clear exactly what that would mean. Within Article 10, you also have protections against non-denunciation. So this is the question of whether you have to provide health and other related information, such as the security condition of the person in whose care you are giving to the state authorities. And this was one of the big things we highlighted as being under-regulated in the law. States have so far not decided to, even in Additional Protocol 2 and Additional Protocol 1, to allow all medical caregivers to be immune from having to report on the security status of the people under their care. And in fact, depending on the provision allows states to, it subjects the international norm of non-denunciation to protections to those provisions of domestic law. So if the domestic law, which, query whether or not that has to give effect to, the right to health under international human rights law, if the domestic law requires medical caregivers to report on the security threats emanating from the hospital in terms of who's being treated there, the medical caregiver would be required to comply with that obligation. I think it's not fully robust protections here, and I think it goes down to the rationale of why states protected medical care in the first place, which is that they thought that once they're out of the fight, should be protected, should have medical care. But IHL also bakes in, as it does in so many other ways, considerations of military necessity and humanity. And states were not willing, or at least have not been willing so far, to go so far as to say that with respect to anyone under your care, that you have no obligations to report to the warring parties, and indeed they subject that norm to domestic law. I'm going to hand it back over to my colleague Naz just to follow up quickly on with some comments.
Thanks, Dustin. I just wanted to highlight Donatella's question, because I think it's one that also comes up a lot and certainly seems to have been in the mix as we've been discussing the attack on the MSF facility in Kunduz, Afghanistan. And that is the question of, what if you have a fighter? Let's forget about the terrorist distinction right now. What if you have a fighter in a situation of armed conflict, and the fighter is directing from his phone attacks somewhere else, engaging in some way in hostilities from within the protected medical facility? One, what are the obligations of medical caregivers in that situation, that they see that? And two, what does that do to the protection for both the facility and the medical care that is going on there, as well as the wounded individuals who, of course, are themselves protected by IHL? Dustin, if you could quickly take those on. I think those are questions that a lot of people are thinking through in terms of the obligations of the medical care providers to prevent people under their care from engaging in hostilities. And then second, at what point can protection be lost due to engagement in hostilities from within the protected space?
Excellent. So just quickly taking those two questions. The thumbnail version of the obligations to prevent here. So medical caregivers are protected as a corollary. They are, if states have said that they will limit the protections for medical caregivers in these areas, even though they're very high, to legitimate matters of security in terms of search and other things, so that if a state thinks that you are caring for someone who is of interest to the state, and the domestic law peacetime counterpart to this is if there's a gunshot wound victim at the hospital, the state can come in and legitimately search, so long as they don't interfere with the underlying medical care that's being provided effectively to the person. So the state can't require, and indeed the medical care provider is under an obligation, not only under the law of international humanitarian law, but also under their own medical ethics and codes, to provide, to the best extent feasible, medical care based on the considerations that are promulgated, including that you should provide, based on the available resources, triage to the people who are most in need of it, irrespective of their affiliation. Now, with respect to attacks on healthcare facilities or on medical personnel, medical caregivers, etc., it's a very specific legal regime that requires a very specific legal analysis. It requires you first to look and see what the international armed conflict, whether or not it's international armed conflict or whether it's non-international armed conflict. Again, assuming it's non-international armed conflict, because a lot of these issues arise with respect to non-international armed conflicts, again, though not exclusively. Common Article 3 is not going to provide you any explicit treaty-based protections. ICRC argues that customary IHL does, and I would agree. And then that is rooted primarily in Additional Protocol 2. Additional Protocol 2 says that those units and transports, and the commentary argues that medical personnel as well, and again, I agree, I think this is persuasive, are protected so long, they must be protected and respected, and they cannot lose those protections unless they are used to commit or commit to themselves hostile acts. It's phrased slightly differently in Additional Protocol 1 and in the Geneva Conventions for International Armed Conflict versus Non-International Conflict. But the upshot is that so long as you're engaged in impartial medical care in the whole slew of activities that are considered medical care, and under IHL, that's almost everything, you are protected from direct attack. If, however, and you can include, for example, you can even have light weapons on the medical establishment site in order to protect yourself. You're in a war zone. If it's for self-defense only, certain IHL treaty provisions recognize that you could even have light, small arms. But once that protection is lost, there's a warning requirement. There's a number of different approaches within the scholarship concerning exactly what that entails, but I can point you to the exact treaty provisions. Effectively, it means that even if a protected, so a medical unit transport of personnel who's been assigned and recognized by a party to the conflict, so long as that person or unit or transport is engaged in protected activities, they cannot be subject to direct attack. And if they, even if temporarily lose that protection, an advance warning must be given, setting in all appropriate circumstances, a warning notifying them, and only after that has gone unheeded, again, depending on the reasonableness of the circumstances, may that be directly attacked, and then only proportionate to the threat emanating from it. The very short answer here, and the most important thing, is states have, for 150 years, said medical care is above the conflict. Whether the specifics get very specific and get very tricky, and they matter a lot for counterterrorism concerns. But when it comes down to it, these underlying normative protections are at risk of being eroded when states say that actually only medicine, and this is under the U.S. law, only medicine, medical substances, is protected. Any other form of medical activities, when provided to a designated terrorist, is considered to be criminal material support to terrorists, and they don't recognize an IHL-based exemption to the law. So with that, I'll hand it over to Anherod to see if we might have some more questions.
Okay, great. Thank you, Dustin. We do have Elizabeth Holland on the line with a question, so we're going to turn to her now. Over to you, Beth.
Hi, thank you, Anherod, and thanks for the presentation, Naz and Dustin. I think I speak for everyone when we say it's been incredibly illuminating. I have a question that follows on what Dustin was just speaking about. And Dustin, you mentioned that under IHL, there's the phrase commit hostile acts or acts harmful to the enemy. And these are very important when determining whether or not there's been a loss of protection. And I understand that these aren't defined in the law. So I was wondering if you could provide us maybe some guidance or examples of what these phrases mean in practice.
Thanks very much, Beth. It's always so nice to hear from you. Yes, absolutely. So as you mentioned, these aren't defined explicitly in the law. So then what do we need to do? Of course, from public international law perspective, we would need to look at the drafting history to find what the intent of the framers of the drafters of these legal provisions are, and then we can look at subsidiary means, including the application of these norms in contexts such as international criminal tribunals, to see exactly how states have given effect to them, and then look at how states have implemented them with respect to their military manuals, and in other forms of state practice that would help us figure out exactly what customary law now might say about that to support the underlying treaty norm. And I think the main upshot of it here is that hostile act or used outside their humanitarian functions mostly means the medical personnel, units, and transports that is under the control of the party is all of a sudden being used not for its underlying humanitarian purpose, which is medical care, even to the enemy, and instead is being used for belligerent purposes. The archetypal example that the ICRC gives with respect to Article 19 of Geneva Convention 1 in their commentary on that is that as a enemy approaches a hospital or medical unit, and the enemy is receiving fire directly from, so receiving gunfire directly from the hospital, that the warning requirement might be extremely small, if any, and that all of a sudden they may repel that fire because in self-defense, emanating directly from that hospital. That's the quintessential example. There's a lot of room for interpretive space at the margins of this, but I think the underlying norm just has to be kept in mind that so long as medical care is being provided, and so long as the hospital isn't been converted into a military objective based on the relevant criteria, it has to be protected. What's really tricky in the counterterrorism space is that not a lot of the times in Syria, for example, a lot of the medical care units, personnel, and transports aren't those that have been assigned by the parties to the armed conflict as such, and thus wouldn't necessarily fall under the AP2 or what the ICRC and others would consider, and I would agree, equivalents under customary IHL. And so then those units, transports, and medical caregivers wouldn't qualify for the special protections as such, but instead would qualify as civilian objects or civilians, which of course also can't be directly targeted, but the warning requirement might be a little bit different in that context. I wouldn't want to go too far down that path without being more specific about particular facts or whatnot. I think the underlying point that counterterrorism all of a sudden revises this, and in the most extreme scenario, if you look at some of the statements of the Syrian regime and their domestic law from 2012, it more or less recasts medical care as direct participation in hostilities or the equivalent, and that to me is where the real danger lies in ultimately revising what was a protected form of humanitarian assistance, the foundational compromise, if you will, of the laws of armed conflict to provide medical aid to the enemy or to combat, is all of a sudden considered something that can give rise to targetability under the law. I think this is something that just has to be kept in mind.
So if I could I'm going to do my best to sort of take a few of the questions that we're getting and reframe them to capture most broadly some of the concerns. So if you forgive me, I'm going to take a bit of liberty with some of the questions. So one question coming from Sama of cases, and that is we're all familiar with the debate on direct participation in hostilities. And the question being, at what point could the counterterrorism definition of material support to terrorism overlap with the notion of direct participation in hostilities such that doctors and medical professionals could themselves be seen as lawfully targetable? And is that in some ways what we're seeing in Syria? So that, I think, is question number one, a crucial question that I think we need to think about. The second question, and here I'm bringing together, I think, sort of Dismas's question, but also some of what Valerie's talking about in the comments, and that is, and Dustin, if you'll forgive kind of the pedestrian nature of the way I'm going to frame the much more sophisticated questions, what were states thinking? How could this protection be as significant as you're saying? What was in it for states to agree to actually protect people from denouncing their patients when that information could be so valuable? Can you just talk to us a little bit about the rationale here, as peculiar as it sounds in some ways? Over to you.
Thanks very much, Naz and Valerie, and the others for this question. I think, so on non-denunciations, it really makes sense, I think, to just focus on this for a second. So what do we mean here? So Alexander Breidiger, a legal advisor for the ICRC, has a really great section in an article that he came out a few years ago exploring exactly what non-denunciation protections are, how the IHL protections overlap with the international human rights law and international criminal law provisions. What it says in short is that what's at stake? What is at stake here is whether or not a medical caregiver, so whether they're a physician, a nurse, or anybody else who are providing medical care to an enemy wounded in an armed conflict, if the state under whose control that person finds himself, whether it's in their territory in a situation of belligerent occupation, or the state in a non-international armed conflict, or an invading state in a non-international armed conflict, can that state require the person to provide information on who's being treated? And why would this come up in the laws of war? This initially came up during the drafting of what would become the 1949 Geneva Conventions. Ultimately, the drafters did not include any non-denunciation protections in the 1949 conventions. Nonetheless, the rationale underlying the initial discussion was that during World War II, there were grave abuses against people who provided support to the enemy in places like Germany or Russia or Japan, who were shot at gunpoint, who had no judicial process, and who were considered to be conspiring with or providing unlawful aid to the enemy, and were just shot, sometimes just shot on the spot. States, however, were very careful to try to craft the international humanitarian law provisions in a way that did not give up more sovereignty than they thought was legitimate to give effect to their legitimate security concerns. What the result was is that in Additional Protocol 1 and in Additional Protocol 2, you have it phrased slightly differently. Additional Protocol 2, Additional Protocol 1 allows some protections so long as you're in the hands of an adverse party, so not the party of your own state. You have very strong non-denunciation protections. However, if you're in the party of your own state, you have fewer. Additional Protocol 2 is way more important, though, as we've noted here, because it relates to so many more conflicts involving terrorists, and this is where the tension is sharpest. Under Additional Protocol 2, Article 10, the non-denunciation provisions are subject to domestic law. That's how far states were willing to go in the drafting of Additional Protocol 2. Now, did this actually matter? Was this a point of contention during the drafting? The answer is an unqualified absolutely. Norway, the delegation of Norway, almost left the entire diplomatic conference because they were so concerned about subjecting an international legal norm to a domestic law. This is not only bad drafting at the international level. You can't have an international legal system if every state can just interpret it in their own way and have no uniformity. But it also, to Norway and to many other states, raised a grave concern that the people who would be providing medical care could be compelled to provide that information, and ultimately then the people who would be seeking the medical care just would not seek it. Yet, as we know, out of the diplomatic conference, ultimately, states agreed to subject the underlying international legal norm to the domestic law. Whether this is an area that states would consider further, quote, progressive, unquote, development of IHL, I don't know. But it's one where states have balanced those considerations of military necessity alongside humanity, and ultimately falling on the side of, for this element in particular, we're going to ensure that states can give effect to their legitimate security concerns. So yes, you can provide the medical care, but then you also have to provide information on the person. Whether or not that may give rise to a conflict with applicable medical codes, medical ethics for physicians, for nurses, for other medical care providers is a matter of domestic law to which the international legal norms are would need to be read in tandem with. Back over to you, Onherad.
Great, thanks. So I would like to go to Naz and ask her to address Ilya's question that came up in the chat. But before doing that, I just wanted to mention for Professor Tobes. We'd like to bring you in after addressing Ilya's question so that you can come on the air. So Marcus will hook you up with the audio in that way. I just wanted to give you a call out in that regard. So now back to you, Naz, for Ilya's question. If you wouldn't mind reading it out again or paraphrasing for the group.
Yeah, absolutely. Thanks, and Herod. So I think Ilya's question and her really important point I think that you raised, and I'll again sort of both paraphrase and make it a little more broad if you allow me, is what is the legal requirement for impartiality? Where are we getting this notion that medical care providers need to provide care impartially to the wounded and sick, to those that are sort of approaching their facilities? And is that sort of an additional obligation that's being presented on medical care providers? Is that explicitly required in the law, or are we sort of reading that into the requirement for medical care in armed conflict? Dustin.
Excellent. Thanks, Ilya, and thanks, Naz. So the legal requirement, of course, requires us to look exactly what the law says. So with respect to impartiality here, what we mean is that medical care needs to be provided to the individual based on considerations of medical need without adverse discrimination on other grounds than medical need, in line with the available resources to the parties to the armed conflict or to the civilians party in that need. Again, this is an obligation on the parties, so it's primarily devolves onto the people who are authorized and recognized by the parties to armed conflict to provide medical care. That may be in an international armed conflict, the military medical service. It can be voluntary aid societies subject to military law and regulations. It could be even the voluntary aid societies of neutral societies that are neutral states that are sent. And in non-international armed conflicts, those would be the individuals who are authorized and recognized by the state or by the organized armed groups exclusively to provide that medical aid and assistance. But here, it is grounded in the law, especially with respect to the medical personnel who have been authorized and recognized by a party to the conflict. Article 7.2 of Additional Protocol 2, for instance, says that in all circumstances, medical personnel, the wounded and sick shall be treated humanely and shall receive, to the fullest extent practicable and with the least possible delay, the medical care and attention required by their condition. There will be no distinction among them founded on any grounds other than medical ones. Again, there shall be no distinction among them founded on any grounds other than medical ones. This gets to the heart of one of our main findings from the research, which is that irrespective of what a state or the Security Council does with respect to a terrorism designation, that we found that none of the underlying IHL provisions are revised or modified in a way that would remove the underlying protections for a designated terrorist. The counterterrorism legal framework does not modify the underlying IHL obligation. It may create, in some respects, a normative conflict between these two sets of legal frameworks, but nothing within IHL is revised, including its provisions on impartially providing medical care to those in need based on medical need, in line with up against the counterterrorism designation. Importantly, nothing that we saw would also deprive organized armed groups that have been designated as terrorists of the capacity to assign their own medical personnel, units, and transports, and to control those units, transports, and personnel in ways that would allow them to, for instance, display the protective emblems of the Geneva Conventions, such as the Red Cross and Red Crescent. Over to you, Herod.
Great, thank you, Dustin. Now, I believe that we have on the line Professor Brigitte Tobes, and who has been active in the chat with a couple of questions, but also contributing to the discussion, particularly on the subject of medical ethics. And Professor Tobes, I wonder if we could bring you in on the audio for some commentary on that point, and of course, any other points or questions you'd like to raise to Naz and Dustin. Over to you. Okay, Okay, it seems that might not be working. We're going to give it one moment to just double check the connection. Apologies for the delay. We'll be right back with you. Okay, trying one more time. We're unmuting. Professor Tobes, do we
Hello,
have
can
you on
you
the
hear
line?
me?
Yes, yes, we do. There you are.
Can you hear me?
Yes, we hear
Okay.
you well. Thanks so much.
Good afternoon, everyone, and congratulations with this excellent report and presentation. What strikes me is that your overview shows a number of gaps in the field of international humanitarian law when it comes to the protection of patients, including terrorists. There is a sound in my voice. So I'm fully aware that these gaps are there, and it's probably a bit difficult to argue that other things come into play as well when it comes to this discussion. But I've tried to argue in my research that there's an interface between international humanitarian law, medical ethics, and right to health, in particular, human rights law, and patients' rights when it comes to the protection of these persons in armed conflict. And it's probably very difficult to make this argument, but I would say that the gaps in international humanitarian law could potentially be filled up by these medical ethics and right to health. For example, medical ethics strongly emphasize the principle of medical neutrality. And you called it very interestingly, you talked about the impartial medical care, and I talked about medical neutrality, and I think it's quite similar. But I think it has two dimensions. On the one hand, it focuses on the role of doctors and what they should do, and that seems very important in this debate. And it seems that this is a strong principle for doctors, and therefore, the sound is very annoying, I must say. This is a law that doctors have to abide by under all circumstances. So they have to provide impartial care, no matter where they are, in an armed conflict, for example. I'm going to leave it at this because the sound is very difficult. Thank you very much.
Okay, thank you so much. Thank you very much. I'm going to go now to Naz and Dustin. I hope that you were able to hear well enough the remarks, and over to you.
Excellent. Thanks very much. And thank you very much, Professor Tobes. I'm a huge fan of your work. And I think actually the more work that's done within the academic and policy space, trying to identify exactly what the content of medical ethics is, not only under IHL, but under the relevant domestic regimes, as well as within the context of transnational NGOs and others consider them to be, I think that this will help provide us with more and more insight into exactly how we should frame these as a matter of the lege ferenda, the law as it should be. Two main responses to your point. The first one is that I just want to underscore again that the fragmentation in the regime here is one that gets, from our perspective, to the heart of the matter when it comes to state responses to terrorism. A number of states involved in these responses to terrorism, such as the United States, Pakistan, and others, are not party to IHL treaties that impose any of the medical ethics as such related obligations. There are ones that impose, of course, impartiality and other requirements on the medical personnel and others. But when I say that, I mean that the United States, for instance, as a non-party to Additional Protocol 1 or Additional Protocol 2, has no international legal obligation to not punish people based on comporting with medical ethics. And so I think one big background point is that there's no, for some state, there's a potentially very large normative rift between states that even consider these non-punishment and medical ethics provisions to require it to oblige them legally, and then to the states that do consider those to. So in the U.S. Department of Defense Law of War manual that came out this last June, although the manual incorporated almost every additional protocol to medical care protection, it did not include, and the absence was, to my mind, quite conspicuous, of Article 10.1's protections for those who provide medical care that comports with medical ethics, irrespective of who benefits. I think you have to read this this should be read, of course, in a way that comports with U.S. domestic law, which requires, which allows for, the domestic authorities to bring charges against people who provide medical care to terrorists other than medical substances. And so it's the first point being that not even all states recognize that they may not punish people based on providing medical care that comports with medical ethics in all armed conflicts. But getting on to the more substantive question, I would point a number of the people listening here to one of the newest documents that relates to medical ethics, and one that I think really gets to the heart of some of the main issues that Professor Tobes raised, which is the overlap between the IHL considerations, the international human rights law framework, especially the right to health, to the extent to which it's progressively realized based on the different interpretations of the human rights bodies, and incorporating in also international criminal law norms and domestic norms. And that is the Code of Medical Ethics that the ICRC, the International, I believe, I'm going to not get the names correctly, but I believe the International Nurses Association, the Military Medical Ethics Committee, and others agreed to a few months ago. But what was so peculiar, I thought, about that new set of medical ethics, which again is not legally binding as IHL, was that for some of the key protections, it says that the medical care providers must, and this is in the medical code of ethics, comport with domestic law. And so it redounds the underlying normative framework to the domestic legal instrument and doesn't resolve the underlying authority, and I think in some certain respects just does not provide doctors, nurses, other healthcare providers with sufficient clarity as to what exactly should be prioritized when they are giving medical care and assistance. I'll leave it with saying I think this is an area ripe for further progressive development, and one where, but it'll have to get over two big hurdles. The first one is that not all states recognize the non-punishment provisions for comporting with medical ethics under their IHL obligations and their corresponding domestic obligations. And the second one being getting states to agree not to condition certain medical ethics on domestic norms that would in some way subvert some of those in some way. But I do think the right to health is the primary basis within the international legal corpus today to ground that underlying normative commitment. Over to you, Ann-Herred.
Oh, great. Thanks so much, Dustin. And thanks to both of you for sticking with us for an additional 20 minutes. Very much appreciated. It's been a rich discussion, and I'm so glad that so many people were able to join today. We're going to wrap things up now. I'll ask Naz and Dustin, both of you, if you'd like to leave us with any closing remarks, perhaps regarding what's next for work in this area in your view, having recently completed and launched this report.
Yeah, thanks, Ann-Herred. I'll just say two words. One is I think that, and I'm not saying this to flatter our hosts, but I think that the work of organizations like PHAP, both in terms of providing a forum like this one, but also in your broader work in carrying out professional development activities that focus on IHL, our sense in doing this research was at times that even humanitarian professionals did not understand the protections that were rooted in IHL, and I think just awareness and knowledge of the law is really crucial here, one. And second, I think thinking about these legal dilemmas from an operational perspective. So what does it mean to think about some of the challenges that we've identified in this report for purposes of real-life, real-world humanitarian operations? How do you resolve some of these tensions? How do you engage states that are assertively going after terrorist groups and designated terrorist organizations, and how do you in some ways recapture that spirit from 1864 to the present in a way that is meaningful for states that see themselves as genuinely threatened by transnational terrorist organizations? Over to you, Dustin.
Excellent, thanks. I've been extremely prolix in my discussion today, so I will leave it with one sentence. Medical care should remain above the conflict, but for it to do so, it needs to be able to address head-on the underlying contradictory normative framing of some states today, and that is the task.
Okay, very good. Thanks again so much to both of you. It's really been a pleasure. Thanks, Naz, for the encouraging words for PHAP's work. Very much appreciated. And I know that your work and your willingness to give these kinds of briefings and engage in discussion are very much appreciated and very important for the PHAP membership and guests, the wider community of practitioners as well as legal professionals looking at these issues as they relate to humanitarian work across the world. So I'll wrap things up now with a few closing pieces of information. So first of all, today's event has been recorded, and you will be able to access that recording as well as a selection of related resources at the link that you see in front of you there. That will also be emailed to all of you within the next few hours once the recording has been processed and put online. I'll also highlight the next upcoming event in this new series of PHAP expert IHL briefings. This will again be drawing on the research of the Harvard Law School program on international law and armed conflict. The subject of the next briefing follows their report that looks at suppressing foreign terrorist fighters and supporting principled humanitarian action. That will take place on the 17th of December, Thursday, and I hope that many of you will be able to join us again on that date for what I'm sure will be a very interesting and dynamic discussion once again. Then I'll also mention, for those of you who may not be aware, we have a complementary separate series of events looking at issues of IHL and policy, but which are not on the expert briefing track, but rather on the, say, educational or learning track, but also addressing really important questions that are on the front of the minds of practitioners today. The next one in this online learning series on humanitarian law and policy, which is moderated, hosted by our consulting expert on IHL, Elizabeth Holland, whom you heard earlier in the hour, will be on the subject of the strike at Kunduz, and it will be an IHL analysis with guest expert Robin Geis, and again that will be hosted by Elizabeth Holland and will take place on the 17th of November, and I hope that some of you will be available then and or recommending it to your colleagues who may like to walk through an IHL analysis of that incident. Then next, coming up in the online learning series on humanitarian law and policy will be a session looking at the International Criminal Court and humanitarian actors. That will be on the 2nd of December. And again, may well be of interest to some of you as well as colleagues working in the sector. So with that, I'll end with my own quick thank yous. First, once again, to our experts for the day, Naz Modirzadeh and Dustin Lewis. Thanks so much for being with us. I'd also like to thank the whole team here at PHAP, in particular Marcus Forsberg, Leonie Leborn, as well as Saranjana Das for their support, for putting together everything behind the scenes for today's event. Many thanks to all of you, and looking forward to seeing you in the virtual space once again sometime soon. This is Herod Lang, Executive Director of PHAP, signing off from Geneva.